What is USCIS's current position on speculative employment? Can companies file petitions without showing proof of work?
Yes. Again, that's a very important question because a lot of employers are asking that and employees as well. With the new law, I mean, a little bit background on this. There was a court case that was filed by IT Serve, which is a conglomerate of consulting companies, and they filed it against USCIS. And they basically filed it saying that USCIS's requests for contracts and work orders from consulting companies and USCIS's request for showing work for the entire duration of time. For example, if it was filed, H1 was filed for 3 years, USCIS was asking for contracts and work orders for 3 years to show where their consultants are working. They were asking for end client letters. They were asking for vendor letters. They were asking for an itinerary. So they were asking for a lot of things. They were also asking for employer-employee relationship to show in a consulting situation, in a consulting company situation, that the employer is actually the consulting company. And they were asking for proof of that. And they were asking so much evidence that it was almost to the point of becoming ridiculous. So ITServe filed this lawsuit where they said that USCIS should not be asking for all this, and this is not in the law. This is against the Immigration and Nationality Act. As a result of which, USCIS basically ITServe won that case that was called ITServe versus Cessna. And USCIS then issued a policy memo in June of 2020, basically talking about how their policy has now changed. They're not going to be asking for employer-employee relationship anymore. They're not going to be asking for contracts or itineraries involving third parties, for the entire duration of time. Now, a lot of people took this to mean that now H1s can be filed without any supporting documentation. You can just file skeleton H1s. You do not have to show POs and work orders. And I'm talking about this in the context of the consulting company world. So, and there's been some debate about this in the forums that I've been to this year with relationship to this year's H1B cap season. So I just wanted to clarify my thought process on this. So as per the memo, USCIS did agree to rescind the whole employer-employee relationship issue and that they will not ask any more questions. And they haven't been asking any questions on that issue. And also, they have not been asking employers to prove that, work exists for the entire 3 years. They've not been asking for the itineraries for the entire duration of the time and POs to be extended for 3 years. But on the question of speculative employment, that is whether an employer has to show that work exists at the time of filing the petition and what evidence should be provided at that time. They have not, USCIS did not say that speculative employment is now something that is not required. That means they have said that they will review the position. So they will review and see if there is a bona fide job offer. So bona fide job offer is something that has always been there for in the H-1B regs. You have to show that it's a specialty occupation requiring a bachelor's degree, and you have to show that the petitioner has a bona fide job offer. So while they may not ask, they said, for evidence of specific day-to-day assignments, the USCIS has said that they could deny petitions based on the fact that there is no bona fide job offer, which means that you cannot file a H1 based on speculative employment, basically saying that, okay, we don't have a job for the person right now, but once the person starts on our H1, then we will start looking for a job for them, especially again in the consulting scenario. We will start looking for a client or start looking for a PO or a contract for them once they join our employment. So the question is whether that is allowed. As per USCIS, they have not said that it is allowed. They have said that USCIS can issue RFEs based on the bona fide job offer, based on they will want to see proof that there is availability of specialty work. And the only way to respond to such an RFE would be by submitting a contract or a purchase order, again in the consulting situation, showing that you have secured a position for the employee that you're seeking to hire. So is speculative employment a thing of the past? I wouldn't say it is. I think employers should still provide POs and work orders, MSAs, whatever they have, a vendor letter or a client letter, to show that they have a position available and to show the job duties so that they can, USCIS can ascertain that this is a specialty occupation. So that's my answer to that question, Michelle.